Good day, sir. I am Judge Paul B. Piñaberte, and this is my report about the Maritime Labor Convention 2006. The Maritime Labor Convention (MLC) is an international labor organization convention number 186, established in 2006 as the fourth pillar of international maritime law and embodies all up-to-date standard of existing international maritime labor convention and recommendation, as well as the fundamental principles to be found in other international labor conventions. The other pillar are SOLAS, STCW, and Marlaw. The treaty applies to all ships encountered the harbors of parties to the treaty, as well as to all ships flying the flag of state party. Article 1 of Maritime Labor Convention 2006. Each member which ratifies the convention undertakes to give complete effect to its provisions in the manner set out in Article 4, in order to secure the rights of all seafarers to decent employment. Members shall cooperate with each other for the purpose of ensuring the effective implementation and enforcement of this convention. Article 2 of Maritime Labor Convention 2006. For the purpose of this convention, and unless provided otherwise, in particular provision, the term competent authority means the ministry, government, departure, or other authority having power to issue and enforce regulation, orders, or other instructions having the force of law in respect of the subject matter of the provision concerned. Article 3 of Maritime Labor Convention 2006. Each member shall satisfy itself that the provision of its law and regulation respects, in the context of this convention, the fundamental rights to: first is freedom of association and the effective recognition of the rights to collective bargaining, and B, the elimination of all forms of forced or compulsory labor. Article 4 of Maritime Labor Convention 2006. First, every seafarer has the right to a safe and secure workplace that complies with safety standards. Every seafarer has a right to fair terms of employment. Every seafarer has a right to decent working and living condition on board ship. Article 5 of Maritime Labor Convention 2006. Each member shall ensure that ships that fly its flag carry a maritime labor certificate and a declaration of maritime labor compliance as required by this convention. A ship to which this convention applies may, in accordance with international law, be inspected by a maritime other than the flag state, which the ship is in one of its ports, to determine whether the ship is in compliance with the requirements of this convention. Article 6 of Maritime Labor Convention 2006. The regulation and the provision of Part 8 of the Code are mandatory. The provision of Part B of the Code are not mandatory. Each member undertakes to respect the rights and principles set out in the regulation and to implement each regulation in the manner set out in the corresponding provisions of Part 8 of the Code. Article 7 of Maritime Labor Convention 2006. Any derogation exemption or other flexible application of this convention for which the convention requires consultation with ship owner and seafarers organizations may, in case where representative organizations of ship owners or of seafarers do not exist with a member only, be decided by that member through consultation with the committee referred in the Article 8 ay Article 13. Article 8 of Maritime Labor Convention 2006. The formal ratification of this convention shall be communicated to the Director General of the International Labor Office for registration. This convention shall be binding only upon those members of the International Labor Organization whose ratifications have been registered by the Director General. This convention shall come into force 12 months after the date of which there are been registered ratifications by at least 30 members with a local share in the world gross tonnage of ship of at least 33%. Thereafter, this convention shall not come into force from any member 12 months after the date on which its ratification has been registered. Article 9 of Maritime Labor Convention 2006. A member which has ratified this convention may denounce it after the expiration of 10 years from the date on which the convention first came into force by an act communicated to the Director General of the International Labor Office for registration. Such as denouncing shall not take effect until 1 year after the date of which it is registered. Each member does not within the year following the expiration of the period of 10 years mentioned in paragraph first of this article exercise the right of denunciation provided for in this article shall be bound for another period of 10 years and therefore may denounce this convention at the expiration of each new period of 10 years under the terms provided for in this article. Article 10 of Maritime Labor Convention 2006. This convention revises the following conventions: minimum age C Convention 1920 number 7, Unemployment Indemnity Shipwreck Convention 1920 number 8, Placing of Seaman Convention 1920 number 9, Medical Examination of Young Persons C Convention 1921 number 16, Seaman Articles of Agreement Convention 1926 number 22, Repatriation of Seaman Convention 1926 number 23, Officers Competency Certificates Convention 1936 number 53, Holidays with Pay C Convention 1936 number 54, Ship Owners Liability Sick and Injured Seaman Convention 1936 number 55, Sickness Insurance C Convention 1936 number 56, Hour of Work and Manning C Convention 1936 number 53, Minimum Age C Convention revised 1936 number 58, Food and Catering Ship's Crew Convention 1946 number 68, Certification of Ship's Cook Convention 1946 number 69, Social Security Seafarers Convention, 1946, number 70. Paid Vacation, Seafarer Convention, 1946, number 72. Medical Examination, Seafarers Convention, 1946, number 73. Certificate of Abled Seaman Convention, 1946, number 74. Accommodation of Crew Convention, 1946, number 75. Wages, Hours of Work and Money, Sea Convention, 1946, number 76. Paid Vacation, Seafarer Convention Revised, 1949, number 91. Accommodation of Crew Convention Revised, 1949, number 92. Wages, Hour of Work and Money, Sea Convention Revised, 1949, number 93. Wages of Hours of Work and Money, Sea Conventions Revised, 1958, number 109. Accommodation of Crew Supplementary Provision Convention, 1970, number 133. Prevention of Accident, Seafarers Convention, 1970, number 134. Continuity of Employment, Seafarers Convention, 1976, number 145. Seafarers Annual Leave with Pay Convention, 1976, number 146. Merchant Shipping Minimum Standard Convention, 1976, number 147. Protocol of 1996 to Merchant Shipping Minimum Standards Convention, 1976, number 147. Seafarers Welfare Convention, 1987, number 163. Health Protection and Medical Care, Seafarer Convention, 1987, number 164. Social Security Seafarer Convention, Revised, 1987, number 165. Repatriation of Seafarer Convention, Revised, 1987, number 166. Labor Inspection Seafarer Convention, 1996, number 178. Recruitment and Placement of Seafarer Convention, 1996, number 179. Seafarers' Hours of Work and the Manning of Ships Conventions, 1996, number 180. Article 11 of Maritime Labor Convention, 2006. The Director General of the International Labour Office shall notify all members of the International Labour Organization of the registration of all ratifications, acceptance, and denunciation under this convention. Second, when the conditions provided for in paragraph 3 of the Article 8 have been fulfilled, the Director General shall draw the attention of the members of the organization to the date upon which the convention will come into force. Article 12 of Maritime Labour Convention, 2006. The Director General of the International Labour Office shall communicate to the Secretary General of the United Nations for registration in accordance with Article 102 of the Charter of the United Nations full particulars of all ratifications, acceptance, and denunciation registered or under this convention, special tripartite committee. Article 13 of Maritime Labour Convention, 2006. The governing body of the International Labour Office shall keep the working of these conventions under continuous review through a committee established by by it with special competence in the area of maritime labor standards. For matters dealt with in accordance with this convention, the committee shall consist of 2 representatives nominated by the government of each member which has ratified this convention, and the representatives of ship's owner and seafarer appointed by the governing body after consultation with the Joint Maritime Commission. Article 14 of Maritime Labor Convention 2006. Amendments to any of the provisions of this convention may be adopted by the General Conference of the International Labor Organization in the framework of Article 19 of the Constitution of the International Labor Organization and the rules of procedures of the organization for the adoption of convention's amendments to the code may also be adopted following the procedures in Article 15. In the case of the member whose ratifications of this convention were registered before the adoption of the amendments, the text of amendment shall be communicated to them for ratification. Article 15 of Maritime Labor Convention 2006. The code may be amended either by the procedures set out in Article 4 or unless expressly provided otherwise in accordance with the procedure set out in the present article. An amendment to the code may be proposed to the Director General of the International Labor Office by the government of any member of the organization or by the group of ship owner representatives or the group of seafarer representatives who have been appointed to the committee referred in the Article 13. An amendment proposed by a government must have been proposed by or be supported by at least 5 governments of members that have ratified the convention or by the group ship owner or seafarer representatives referred to in this paragraph. Article 16 of Maritime Labor Convention 2006. The English and French version of the text of this convention are equally authoritative. And that is my reporting for Maritime Labor Convention 2006. Thank you, sir.